For more on the day in court and what is next in former President Trump's New York hush money trial, let's bring in our expert legal panel. Jeremy Saland, criminal defense attorney and former assistant district attorney in the trial division of the Manhattan DA's office. Danny Cevallos, criminal defense attorney and NBC News legal analyst. And Bernarda Villalona, criminal defense attorney and a former prosecutor. She was in the courtroom today and is outside of the courthouse there in Lower Manhattan. Jeremy, let's start with you here and the prosecution's closing arguments, which are still going on, as Laura just noted. But at one point, we did hear prosecutor John Steinglass telling the jury that the absence of Trump's fingerprints on the NDA and other documents related to this case, that is not proof of his innocence. He said this: "It's true that Mr. Trump didn't sign these documents himself, but that's kind of the whole point, to keep him out of it." Is it fair to say in that moment he's sort of trying to address a possible shortcoming from their case? And when you look at where we are right now, do you think the prosecution has proved their case in a way that can result to all or most of these counts coming back as guilty?
Well, you have to lead with your strongest point, but at the same time, you can't ignore the weakest points. But from the outset of the case, Pecker came out and said there weren't the emails, there weren't the agreements, there was much more informal. And you heard from multiple witnesses that that's kind of how things went. There wasn't the handwriting, and this is not necessarily just Donald Trump. He's acting in concert with other people, meaning Michael Cohen, Weisselberg, David Pecker, to commit these crimes. So I think they absolutely had to address it. Now, in terms of getting in their evidence, they've done a good job of putting the evidence. But now we're on, hour 4 or 5 of the summation. It's very tedious and monotonous. I think Josh Steinglass did a really good job at a few things, saying, for example, in addressing Blanche's arguments, if there was no records, there'd never be a falsifying business record charge. You need to have those records. It's not as if you would hide them. And when he did that 49 seconds to show how much 90 second really means and how much can happen, he did a great job of trying to address the weak points, trying to address the Blanche's points, and then bringing out his strongest points. And I think they've done a good job.
Danny, help us understand the defense's closing arguments today and how well or not great they did from your perspective, because Trump's defense team, they did only call 2 witnesses throughout this trial. Donald Trump was not one of them. Todd Blanche, he did seem to focus most of his closing arguments today on Michael Cohen, calling him a liar, trying to discredit him, and then specifically going after his testimony about that phone call in October of 2016. How do you think the defense did? Did they craft a possibility of reasonable doubt?
It's so hard for me to criticize the defense and really any party's closing arguments, but I would say they may have overfocused on the Michael Cohen as liar theme. They made the point, you want to try to move on. There were points that I thought they did very well. And really, for the defense, since you're basically pot-shotting, you're not building a case, sometimes it's those little moments. For example, the argument, and Laura Jarrett pointed this out, the idea that the entry for legal services was nothing more than a drop-down menu choice. I thought that was really interesting stuff. So little moments like that may have helped the defense. To some degree, you could say the defense was a little disorganized. But again, they go first, and yet they have to react, in a sense, to what the prosecution is going to say before the prosecution says it. So, I mean, all in all, it's very easy for us to say both the defense and the prosecutor's argument should be shorter. But at the same time, if you're them, this is the most important case of your career. It's not likely you'll ever get another case that is as important as this case. And the terror, I know I've had this terror myself, of leaving something out always incentivizes a longer rather than shorter closing argument. Yes, you could edit. Yes, you could shorten it. Yes, there are probably things in there you don't need. But there is one rule that I always go back to, which is you never know, and you're always surprised at what jurors find really interesting. It's often something you think is just totally inconsequential. And so for that reason, there's every incentive to put in every thought that you have and not be that cautionary tale that, hey, I left something out for brevity's sake, but it was something that the jury would have really, really reacted to. And that's how you get 4.5, 5-hour closing arguments for that exact reason, which is why a lot of judges will shorten them, compel them to be a lot shorter. That didn't happen in this case. Understandable. It's such a critically important case. You want to give everybody a chance to breathe.
All right, Bernardo, let's bring you in here on this idea of the jury's engagement as discussed. These are really, really long closing arguments. And if you're not someone who has studied law, it's very easy to just be like, whew, I'm back in college and I am tired and I have tuned out, been sitting here a long time, no windows usually in courtrooms. What did you notice when you were inside today? Did the jury seem to be more or less engaged during the prosecution's closing arguments or the defense?
Well, it definitely seems that the jury is definitely engaged in the sense that they are eager to get to the end of this case. They are eager to start jury deliberations because even Judge Merchan put on the record, I'm looking at the jury, they look engaged, they look like they're paying attention, they're not dozing off, so we're going to continue with these closing arguments. To the point even that the judge has been stopping probably every 90 minutes or so to try to engage with the jury to see if they can continue on. And even the prosecutor, Joshua Steinglass, at one point was like, even addressed the jury, was like, you're with me. I see you with me, so we can continue on. I'm almost done. So that's a good sign, actually, for the prosecution to have a jury that is eager to continue listening to closing arguments, despite being there since 9:30 this morning and pretty much not with much of a break. And they're listening and they're attentive. So much information is being thrown out at them. I'm hoping that they're able to absorb the major points, because what the prosecution is doing is that they're hitting every major point, but also every minor point as well. And sometimes you can lose the jury when you decide to put every minor point in. But just like Danny says, you don't want to be the prosecutor that at the end of the night, you're like, oh, I wish I would have said this. Or if the verdict doesn't go in your favor, was like, if I would have said this, then it would have been a game changer. But I think that because the prosecution's closing argument is in so much detail, that it may help speed up the deliberation process, because literally ADA Steinglass is going point by point. Instead of summarizing the evidence, he's pretty much restating all of the evidence and the strongest points as well as the minor weak points of the evidence that's been presented. So I find it highly unlikely that this jury is going to be out for a long time, given what the closing arguments look like from both sides. The defense, they did what they could with the evidence that was presented to them. They swung. I'm not sure they really made any hits, but the prosecution is definitely throwing everything in there, and every point is valid.
Guys, let me bring you back in here with Josh Steinglass sort of taking that line by line. Let's re-go through all of it. Do you think as well that the jury could actually deliberate pretty quickly here?
I think they can, but, listen, it is a complicated case, but what Josh Steinglass is doing is he's bringing it back to what the case is about. The defense, I thought, missed their mark at times, and they were a little meandering, and they try to make it solely about, you can't believe Michael Cohen, he's a bad guy, he's a bad actor, and he's got this ugly, terrible, vindictive agenda. And when you heard from Josh Steinglass, he kind of turned that around. And I've used this sort of discussion or example before. If you liked Henry Hill and Goodfellas, and you thought that John Gotti was guilty and you could convict with Sammy the Bull, certainly Michael Cohen ain't either one of those two guys. And it's not just Michael Cohen, though. And that's what they did on their summation, which I thought was very good. They brought out all that foundational evidence that takes it off of his shoulders, meaning Michael Cohen, and saying you can look at some of these, the documents, you can look at the handwritten notes, which really were a home run, even if he didn't have Weisselberg. You could look at McConney's, testimony and saying, in all his time, he's never had, payment doubled to cover for taxes. And you use your common sense and you use that physical evidence and use that testimonial evidence, you get to where you need to go. So ultimately, yes, it can be, but as Danny said before, we'd be sort of taking a guess here. We're not in the mind of the jury. We don't know exactly what they're going to say and think, but this is going in the right direction.
Danny, I got to ask you about that moment when Todd Blanche talked to the jury about the idea of prison time, and Judge Merchan was like, nope, that is not happening here. Only I decide prison sentence. Explain to viewers why that was a big deal in that moment. Because to some people in some states, you might think, well, that is kind of what's on the line, but that's not allowed here, correct?
It's almost a universal rule that you cannot comment in closing argument on punishment or potential punishment. You cannot say, that rule is so clear that I would not even come close to saying something like, this man's on trial for his life. that would be an objection. I mean, I stay so clear of it. I limit myself to this is the most important day of my client's life. And that's it. And even that makes me a little nervous because I don't know if I'll get an objection on that point. I'm exaggerating a little bit, but I'm just trying to stress how much this is forbidden ground, such that making that statement simply couldn't have been accidental. I like to give the benefit of the doubt. It was not an accidental statement. It really couldn't have been.
Bernardo, what did you make of that moment? And tell us, if you can, what the jury was like during that moment. I mean, again, a lot of people watch crime shows on TV, and you probably think that is a really normal thing to say. Clearly, all of the attorneys are like, no, that is the big no-no. Do you think Todd Blanche did that on purpose? And if so, what would be the benefit of bringing that up?
Oh, absolutely. I literally cringed when I heard it because I was like, oh, that's a no-no. And definitely a no-no when you're in front of Judge Merchan, because Judge Merchan is a rule follower. Judge Merchan keeps order in the courtroom. And you know that Judge Merchan doesn't play any games. So I think the attorney definitely knew what he was doing. But of course, he had to put and plot that idea out there for this jury, because in the end, you can't unring that bell. They heard what they heard. So what didn't work in his favor, though, is that after the judge came back from the break, the judge gave a curative instruction to that jury that they are not to consider that statement that was made by the attorney. And I think by the judge doing that, that the defense attorney did lose some credibility in the sense of, look, hey, the judge is giving you a little smack that you did the wrong thing. And it doesn't help that the prosecution, every shot that they can, they are taking hits and blows on the credibility of Todd Blanche. And it's crucial because if you lose credibility as an attorney in front of a jury, they're not going to rely on what you're trying to sell them. So that's not going to play well in their favor. And the prosecution is well taking advantage of that.
All right, Bernarda Villalona, Jeremy Saland, Danny Cevallos, thank you all so much for your time.